Petition 88, which sought to ascertain that Order 60 of 2020 is not illegal, was drafted in bad faith, and further that Section 22 of the Constitution violates the doctrine of separation of powers, especially those powers conferred on the Ghana Elections Commission, GECOM, was dismissed before the High Court on Monday by the Chief Justice Roxanne George. Justice George stated in her ruling that GECOM acted in accordance with the Constitution and was forced to do so given that it had a mandate to remove any and all difficulties arising from the 2020 elections, while she also said that Order 60 is not invalid, nor is it illegal.
I consider and hold that Order 60, and for that matter, its enabling provision, Section 22, did not and have not usurped the jurisdiction of the High Court under Article 163 to determine whether an election was lawfully conducted.
While Justice George further explained that even though the Caribbean Court of Justice, CCJ, did not make any ruling with regard to Order 60 and Section 22, she posited that the court did seek to clarify the two and that her court would be bound by those pronouncements.
I do not consider that these pronouncements are obiter dicta. They are part of the reasoning of the CCJ in its consideration of the David case. As such, these pronouncements are binding on this court. As I ruled in Masinga Jones, the CCJ had in fact accepted that Order 60 was required to resolve the political impasse and provide a transparent method for a national recount so as to complete the election process.
Meanwhile, in a written statement following the ruling by the Chief Justice, the leader of the opposition, Joseph Harmon, described the decision as, and I quote, a clear attempt to protect the installed PPP regime from scrutiny and from being removed from government where they have no right being, end quote. Harmon said that he is extremely disappointed by the ruling, while also stating that he remains fortified that the hierarchy courts will correct this clear injustice which has been wrought on the Guyanese people. Petition 88 was filed at the end of August 2020, following the removal of the Apnu+Afc'S from office that year as a result of an election which lasted for months, the result of several court battles, as well as a national recount exercise. Petition 88 alleges that GECOM overstepped its authority by drafting Order 60 of 2020, which enforced the national recount exercise. The petition also states that Section 22 of the Constitution is unconstitutional, since it confers upon GECOM an authority which originally rests in the Parliament. While the Apnu+Afc's has not outrightly stated whether it will be filing an appeal to the Chief Justice's ruling, in his missive, the opposition leader said, and I quote, "We must appeal this at every level until justice is delivered to us," end quote. Harmon concluded his missive by stating that the Apnu+Afc's cannot and will not be held responsible for the reaction of the victimized, disenfranchised, and marginalized masses. We will continue to fight, and we wish to make it clear that all options remain open to us, the leader of the opposition said. Wendell Badrie, HGP Nightly News.